The court sitting in Lagos acquitted and discharged this gentleman, Ayo Fayose, former governor of Ekiti State. And he was discharged at the no case submission stage. Acquitted and discharged at the no case submission stage. Recall that after he concluded his second term in Ekiti State and handed over to Governor Fayemi, Ayo Fayose proceeded to the EFCC headquarters. Was it Lagos? I think so, Lagos or Abuja. No, Lagos. He went there and wore a t-shirt with the inscription, EFCC, I am here. And so he handed over himself to the EFCC following the invitation that the EFCC gave to him. 7 years after he was taken to the court, he's been acquitted and discharged. Like I said, at the no case submission stage. This is Ayo Fayose in court. He's been in and out of the court like every adjournment. He's always there. This is a criminal charge, and therefore, when you're standing trial, a criminal trial, you must be in court for every adjourned date that the matter is fixed. So for 7 good years, Ayo Fayose was in court. This is Ayo Fayose. These are officials of the EFCC. What was he taken to the court for? Offenses of money laundering. Several counts of the offense were preferred against him at the court. But now, the court has set him free of all the charges, like I said, at the no case submission stage. Now it begs the question, what is this no case submission? How is it that this no case submission thing is so powerful to the extent that big charges can be preferred against someone, and along the way, he is allowed to go home on no case submission, a ruling of the court on no case submission. Let's look at it. No case submission is one of the defenses available to every accused person. Not only Ayo Fayose, every person that is standing trial in a court of law in this country and in any other common law country is entitled to the defense of no case submission. There are many defenses available to an accused person. An accused person can go to the court at the beginning and say, my lord, the charge that has been preferred against me is defective. I want you to quash it. That's a defense. The accused person can also wait in between the case of the prosecution and the case of the defense. In the middle, he raises a no case submission. The accused person can also refuse to raise a no case submission and then rolls the matter to the end and raises other defenses. But no case submission is one of the prominent defenses available to every accused person in a criminal trial. It is a situation where the accused person says to the court, my lord, I have carefully listened to the case presented by the prosecution against me, and I hereby state with the greatest respect that no legal evidence has been presented against me so far to warrant my being invited to defend myself. I've listened to the case of the prosecution. I've analyzed the evidence presented by the prosecution against me. There is no evidence acceptable to the law that the prosecution has been able to present against me. The documents presented, the photographs, the videos, the testimony of the witnesses of the EFCC, all of these, when placed on the table side by side with the requirement of the law, they have not satisfied the requirement of the law against me. And for that reason, I am raising this no case submission, that there is no case against me whatsoever. It means that there is no case for me to answer. That's the accused person saying, my lord, there's no case for me to answer. Honestly, there's no case for me to answer. It means that the ingredients of the offense for which I have been brought here have not been proved. Every case must have ingredients. Every allegation has ingredients in law. If somebody is accused of murder, for instance, killing someone, 3 ingredients must be proved by the prosecution. 1, that somebody died. Number 1, that somebody died. Number 2, that that person was killed by the accused person. Number 3, that the action of the accused person was such that the accused person ought to have known that death would be the probable consequence of his action. Now, the prosecution, these are the ingredients of the offense of murder, 3 ingredients. the prosecution goes to court to prove this first one, that somebody died. It's always very easy to prove this one. Somebody died, photographs are presented, autopsy reports is presented by the pathologist to the court. It proves the first ingredient, which is that somebody died. Then the second ingredient should be that it is the accused person that killed this man. If the prosecution is unable to prove this, then the accused person can raise a no-case submission and say, my lord, the basic ingredients of the offense of murder have not been proved against me. And when this happens, the law says I should go home. So that is where we talked about the ingredients of the offense. Even money laundering, there are ingredients for the prosecution to prove. In Fayose's case, he basically said, my lord, the prosecution has not proved the ingredients of the offense of money laundering against me, and for that reason, I hereby raise a no-case submission and I pray your lordship to allow me to go home. Now, the accused person is also telling the court, my lord, when this happens, when the evidence has not been presented, ingredients of the offense have not been presented, out of the 3, 4, 5 ingredients that the law has provided against anybody who commits this offense, the prosecution has not been able to establish anyone against me, or has established one and has not established the remaining 4. I should be allowed to go. He's basically saying, my lord, when this happens, the law is that you should discharge and acquit me and allow me to go home. If the judge agrees, that is the end of the case. Complete end of the case. The accused person goes home completely free, as if the case had been tried to the end. He goes home. Now, there are basically 2 stages in the trial of a matter. The stage where the prosecution presents its own case. And the second stage is the stage where the defendant presents his defense. In between the case of the prosecution and the case of the defendant, there is a middle here. The middle here is where you have the no-case submission. Now, when the prosecution is done with his own case, calls his witnesses, presents his testimony, his documents, the accused person here has the right to raise a no-case submission at this stage before even entering this box. This is the box, the witness box. He refuses to enter the witness box but stays here to raise the no-case submission and says, my lord, the law is that you should discharge me at this point. I don't even need to enter the witness box and testify because so far the prosecution has not proved the ingredients of this offense against me. Now, at the stage that Fayose has been allowed to go, he has been allowed to go without even entering this witness box. He has not entered the witness box. He only stayed at the dock and then raised his no-case submission and is allowed to go. If the no-case submission of Fayose had failed, he would have entered the witness box to testify in his defense. But at the time he was discharged, he did not even enter the witness box. And that's the power of no-case submission. Anybody that is taken to the court, if you raise a no-case submission and it works for you, it is a very powerful defense. That's the end of the matter. Now, there are basic questions here. Can the case be refiled by the EFCC? Can it? Can they just get angry and say, no, we disagree with the judge, we're going to refile this matter? The answer is no. That's the end of the matter. They cannot take the same set of charges against Ayo Fayose anymore in any court of law in any part of this country. That's the end of the matter as regards the charges that were proffered against Fayose in that court. Ayo Fayose goes home. This is the end of the road on those charges. So he goes home, a free man. Right? But can the EFCC go on appeal against the ruling of the trial judge on the no-case submission? The answer is yes. It's a final decision of that court. After that, nothing else is left to be done by the same court. So, when there is a final decision like that, the EFCC has a right to proceed to the next court without leave, as of right. Go to the next court, which is the Court of Appeal, and challenge the ruling of the trial court. When that is done, the Court of Appeal has the power to do one of two things. The first thing is for them to agree with the trial court that there was no case. And that's the end of it also. The second thing for the Court of Appeal to do is to say, no, the trial court was wrong. From what we have seen here, a prima facie case had been made against Ayo Fayose, and he was not supposed to have been discharged. For that reason, we hereby order that this matter be sent back to the Chief Judge of the state or the Chief Judge of the Federal High Court, depending on which one applies, for the matter to be tried by another judge, not by the same judge that pronounced the no case submission ruling, another judge altogether. If that is done, Ayo Fayose returns to the court. But if the first one is done, Ayo Fayose remains a free man, and nobody can prefer the same set of charges against him anymore in any court of law in this country. EFCC, they've been losing many cases at the no case submission stage like this. Ayo Fayose's one is not the first, and I'm sure it's not still going to be the last because they have a lot of cases in court. Most Nigerian citizens have complained about EFCC losing their cases even at the no case submission stage. Remember Saraki's case? When Saraki was Senate President, he was standing trial at the Code of Conduct. That one was prosecuted not by the EFCC, but another agency of government. He still left at the no case submission stage. Remember the case that was prosecuted against Mr. Paul Usoro, Senior Advocate of Nigeria, who was the then president of the Nigerian Bar Association. It was prosecuted by the EFCC. Paul Usoro still left at the no case submission stage. Lots and lots of people have left at the no case submission stage, despite the volume of the charges preferred against them by the EFCC and by any other prosecution agency. Now, what are my suggestions? I like to make recommendations, in ending my videos. One, EFCC should investigate thoroughly before prosecution of cases in court. Without thorough investigation, your case will certainly fail. Two, EFCC should do more of the legal than the media. It's as if when someone is to be taken to the court, you first of all hear so much about that trial in the media. So much is said in the media. It looks as if so much concentration is given to the media angle than to the legal, than to the evidential angle. You need evidence. You need to prepare your witnesses with evidence. People that investigated the matter have to come and testify in court and testify knowing fully well that the law requires you to prove ingredients, not media reportage. So the EFCC should spend more time on the legal than on the media. Three, EFCC should think of reducing their charges to what can be proved. I've seen instances when EFCC started during Ribado's time, that was the beginning of their trial and all that. I was in university that time, EFCC could have as much as 70, 80, 90, 100 count charges against someone. Time has proved that it's difficult to establish 100 count charges against anybody. So why are you going for plenty count charges? Reduce it to 2, 3, 4, maximum 10. Concentrate on them. Have evidence to link them up with the accused person, and then have him convicted by the court. Instead of spreading it into 50, 60, 70, making it bogus at the end of the day is difficult to prove. Remember that the law requires that you must prove all these things beyond reasonable doubt. So you must reduce it, my suggestion, to something like 3, 4, 5, maximum 10 count charges. Every man's offense can be summarized, kept brief, and easy to prove. 4, having a good legal team, whether on the side of the prosecution or on the side of the defense, is very significant in every criminal trial. You need a smart defense team to be able to raise a no-case submission, pick the loopholes, see what the prosecution has not proved, and be able to raise it before the court and win the case for you. You also need a good prosecution team to be able to prosecute and make it impossible for no-case submission to be successfully raised. Many thanks for watching. Do remember to subscribe to the channel and also share so that your friends and loved ones can get to be on this discussion, platform where we informally discuss issues of law. Many thanks.